I'm Drew Stevenson. This is a lecture for my professional responsibility class about ABA Model Rule 5.7, ethical responsibilities regarding law-related services. Just to give my students big picture what we're talking about, there's a lot of things that lawyers do for clients that a non-lawyer could also do. Lobbying, accounting, title insurance, those are three common ones. And so if you can do those things, some lawyers will integrate those into the legal representation that they offer to their clients. And it's a way to add value to what you can do for the clients. It's sort of a one-stop shop. And the question arises, do your ethical duties as a lawyer under the model rules apply when you're technically not wearing your lawyer hat? Maybe it's part of the representation or related to the representation, but at that moment you're doing something that non-lawyers also do. So let's see what the ABA has to say. I'm going to start here with comment 9 to rule 5.7 because it helps clarify what we're doing. Normally I would dive right into the rule, but comment 9 gives a list of very helpful examples that will help you understand the rule. A broad range of economic and other interests of clients may be served by lawyers engaging in the delivery of law-related services. So in other words, there's a lot of things that could come under Rule 5.7. Examples of law-related services include providing title insurance, financial planning, accounting, trust services, real estate investment counseling, legislative lobbying, economic analysis, social work, psychological counseling, and tax preparation, and patent, medical, or environmental consulting. Again, these are things a non-lawyer can do, but maybe your law firm or you as a lawyer also have these credentials or the background so that you can do these things for clients too. So let's take a look at our rule. 5.7a, we're going to have an A section and a B section to this rule. A lawyer shall be subject to the rules of professional conduct with respect to the provision of law-related services, as defined in paragraph B, if the law-related services are provided, 1, by the lawyer in circumstances that are not distinct from the lawyer's provision of legal services to the client. So here we're talking about you do some other things for the client, like accounting, that are seamlessly integrated into your, let's say, tax representation, or you do lobbying that's seamlessly integrated into other legal work that you do for the client. So of course, if you really can't disentangle or unbundle the non-lawyer tasks that you're providing for your client with your lawyer tasks, then the model rules are going to apply. What are we talking about here? Duty of confidentiality, the duty to be careful about conflicts of interest, other types of duties of disclosures, duties about fees, and so forth. You're not going to be able to say, the rule shouldn't have applied to me right then because I was technically doing something else, if it's integrated into the representation. We have a part 2 here. The model rules will apply to the provision of law-related services in other circumstances by an entity controlled by the lawyer individually or with others if the lawyer fails to take reasonable measures to assure that a person obtaining the law-related services knows that the services are not legal services and that the protections of the client-lawyer relationship do not exist. So what are we saying here? Let's say that in order to kind of make it distinct, you opened up an office next door that you own that's a title insurance company or an accounting firm, right? Or maybe your firm owns it, or maybe you sit on the board of directors for the accounting firm or title insurance company across the street, and you refer all your clients there. Well, if you're going to do that, then A2 is really a disclosure requirement. You have to explain to the client, by the way, we're going to have to do this as part of your matter, and my firm will handle this, and you should go across the street or next door for this component of it. And then you have to explain something like, that's not really legal representation, and the ethical duties or obligations I have to you as a lawyer aren't going to apply there, even though I own that, or I sit on the board, or my firm has an ownership share in that title insurance company or lobbying firm or something like that. So you really have to spell it out if you're trying to do this. In other words, you can't just open a side business and get out of your ethical duties without telling the client what's happening, that does something that you are going to have your clients do or refer them there as part of the representation. Here's our definition section 5.7b. The term law-related services denotes services that might reasonably be performed in conjunction with and in substance are related to the provision of legal services and that are not prohibited as unauthorized practice of law when provided by a non-lawyer. In other words, the way we're defining law-related services is things that not only can non-lawyers do, but it wouldn't be considered practicing law without a license if someone does. So if someone's a lobbyist, they're not practicing law without a license, even though lawyers also do that. Okay, we're almost done, I promise. Here's our quick review question to see if you're paying attention. If a lawyer provides legal representation and also offers tax consulting services to clients integrated into the representation, must the lawyer comply with the model rules while performing those non-law services? A, yes, or B, no. Now, hopefully you know the answer to this. It's supposed to be an easy question. If you're stuck, you really should rewatch this video. And that concludes our lecture on ABA Model Rule 5.7, and that's a wrap for our section of the model rules that start with 5 that relate to law firms and associations.